So what are the biggest myths about estate planning? There's actually two that I run across most frequently. One is that a lot of people think a will covers every estate planning contingency and all you need is the will and you're good. And that is absolutely not true. A will doesn't cover what happens if you are incapacitated or disabled, and it might surprise you, but the will has to go through probate. It has to be filed with the court. A lawsuit is actually commenced in order for a will to be effective. So that's myth number one. Number two is that a lot of people believe that if they are incapacitated or disabled and married, then the spouse automatically or exclusively can act for them. And that is actually not true either. Even if you are married, there is no presumption that your spouse has your best interest at heart. And so your spouse would actually have to go through the probate court as well. If you're needing medical decisions, financial decisions made on your behalf, then your spouse actually has to go through that court process just like anyone else in order to get that permission to act on your behalf. So the probate judge will not merely rely on the fact that you are married or that you have a will in order to cover your estate planning concerns. If you have other questions about what that means, what is a will, what does it cover, what do I need to have in place for my spouse to be able to act for me or someone else, then check out the other FAQs and you can see a little bit more about those topics. But that would be the second thing that I find most commonly is a surprise to most families, is that your spouse cannot automatically act for you. And I always tell everyone that if your spouse was always the one that had your best interest at heart, whether it is financially or medically, then we wouldn't have shows like Dateline or 2020. So unfortunately, that is what it is, but you do have to go through the legal process in both of those scenarios.